Uh, I will ask you to silence your telephones or cell phones. And if you are interested in testifying, you can sign up over there by Jennifer. And it's by the door over here. And as a reminder, there's no signs permitted in the committee rooms. And there is an overflow room in case we get overflowed next door at 129. So, Mr. Secretary, will you please call the roll?
Senator Berg. Senator Boswell. Here. Senator Harper Angel. Senator Higdon. Senator Meredith. Present. Senator Smith. Senator Westerfield. Senator Williams. Here. Senator Wilson. Here. Vice Chair Deneen. Here. Chair Girdler.
Here. We do have a quorum. Now we're going to ask Brother Boswell to lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Senator Brother Meredith is going to lead us in a word of prayer.
If you would please bow with me. Dear gracious Heavenly Father, we thank you for this precious gift of life you've given us in this day in particular. Help us to use it to do your will and to glorify you, dear Lord. We thank you for the countless blessings you've bestowed upon us, but particularly the opportunity to serve the constituents of this state. We ask for your divine guidance and the strength to make decisions that are in the best interest of everyone. Reminded of Jeremiah 29:11, we know the plans we have for you, saith the Lord, plans to prosper you, not to harm you, plans to give you hope in the future. Help us to use that whenever we make decisions on the best welfare of the people of this state, dear Lord. We thank you again for the countless blessings you've bestowed upon us. Ask your blessings upon each and every person within this room today. Bless our state, bless our commonwealth, bless the United States of America. We ask these things in your Son's name. Amen.
Amen. Thank you. First on the agenda is going to be Representative Michael Meredith, and it always pays to be a chairman over at the House, and so I call him first because he's in banking and insurance, and I'm on banking and insurance too. So, Chairman Meredith, if you scratch my back, I'll scratch yours.
Thank you, Mr. Chairman. And I do certainly appreciate that courtesy this morning on an early Thursday morning. It's a pleasure to be in front of you all in your committee today. Again, Representative Michael Meredith representing the 19th House District, which is Edmonson and Warren County.
Juan Reno, Deputy Commissioner, KDVA.
Silas Session. I'm the Executive Director for the Office of Kentucky Veteran Service with KDVA and also a co-chair for the Governor Challenge.
Those of you all who served on the Interim Joint Committee back during the summer heard testimony from one of my constituents, Mr. Mike Stoyanovich from Edmonson County, about this issue. We know that nationwide and specifically in Kentucky, the rate of suicide amongst the veteran population is much higher than the general population. There are lots of reasons for that, obviously, but this bill seeks to start down the path of trying to address that issue and create prevention programs out there. We know there are a lot of resources. Many of those research sources fall under the Cabinet for Health and Family Services, but we really need intake better at the Kentucky Department of Veterans Affairs, and we need to break down that barrier between the two departments so they begin to start talking to each other and sharing the resources that are available so we can wrap around as many services as we can. And I think as we go on in this process, what will also happen is they will be able to discuss and figure out what the additional services are that need to go on top of the services that already exist to help dealing with this situation. Frankly, it's a common sense bill, and if it saves one life, it will be worth all of our efforts here that we have today. Be happy to answer any questions that you may have on that. There is a committee substitute. The committee substitute simply adds language from another House bill that was filed by Representative Bobby McCool that would require the Department of Veterans Affairs to create a poster, an employment poster, with veterans resources that then could be, it's not mandatory language on the employer, but employers could then post in their workplaces to provide those resources to their veteran employees. Again, that's what the sub does. I can answer any questions about the sub or the original bill that you all may have.
Thank you. We got a motion and a second on the sub. All those in favor of the sub signify by saying aye. Aye. All opposed, say nay. All right, committee sub is adopted. Any questions? Got a motion on the bill, got a second. Motion, I'll let you answer. Motion by Senator Meredith, second by the guy that says his name wrong, Jay Williams. Senator Boswell.
Since I'm on A&R, I did just have one question. So do we have any idea about what costs are going to be involved in this?
So we don't believe that the bill before you will have any cost. This is about utilizing existing resources and making, again, breaking down that barrier so CHFS and their resources are talking to KDVA and their resources and having a collaborative program that brings those two together. I think there will be a point in time as this process continues. They do have to report back to us and the governor each year about the progress of the program. And I think as those reports come in over the forthcoming years, that's when you will see there might need to be money allocated to additional programs or overlaying other services over the resources we currently have.
And I think my number one concern is something I think you've already addressed, is trying to rein everybody in and try to get them all on the same page, because there are multiple, like for example, I believe right now, if you called 988, no matter if you're a veteran or just a person that's a member of the public, and you would get some help. But reining everybody in, getting us all into one group, I think is a good thing. Thank you.
And obviously, as you said, Senator, those resources exist, but there might need to be a more specific, tailored approach for the veteran out there because of the different experiences they've had that have led them down this path.
Thank you, sir.
All right, we've got a motion on the bill and a second. Mr. Secretary, please call the roll.
Senator Berg, Senator Boswell, Senator Deneen, Senator Harper Angel, Senator Higdon, Senator Meredith.
Display my vote, please. I vote aye and certainly support this bill. I see it as you've already answered. It's awareness and coordination of our efforts, and we haven't done a very good job of that. Have to admit, in the body of the bill, I was a little bit concerned about the involvement of the Cabinet for Health and Family Services, but I don't know how you keep them out of it. But it's just such a big cabinet, and but maybe the reports that we're going to receive on this, we can do a better job of finding some way to coordinate that as well. But I commend you for the bill. Thank you.
Senator Smith, Senator Westerfield, Senator Williams, Senator Wilson, Chair Girdler.
Aye. Now we need a motion and a second on the title amendment. Got a Senator Meredith and got a second Senator Boswell, whatever. All those in favor are signifying by aye for the title amendment. Aye. And those that say nay, say nay now. Did you say nay? Oh, all right. I thought you said nay. I thought, thank you. The title amendment is adopted. House Bill 30, as amended, passes with favorable expression. That same should pass.
Thank you, Mr. Chairman, members of the committee. Appreciate your time this morning.
Thank you. All right. Next on the agenda is House Bill 86, and Bill Wesley, will you come forward with your guest and introduce yourself? Bill, there is a Senate substitute to House Bill 1. You want to address it first? And
Yes,
then-
good morning, Mr. Chairman and committee. Thank you for having us this morning and standing in the gap for our National Guard. The sub here is just a title basically of Michael Stallings is added to it. And what this is in memory of this soldier that gave his life and sacrifice him and his wife. But anyways, he wasn't allowed to be buried in one of our cemeteries, state cemeteries. And so we're going to try to do this in memory of him, Mr. Chairman.
Got a motion on the sub? Motion and second. All in favor say aye. Aye. Any opposed say nay. Motion passes. The committee sub is adopted. Now you can explain your bill.
Yes, sir. My name is Bill Wesley, State Representative from the 91st District over Estill, Powell, and a little bit of Madison. I'd like to introduce my guests here.
Al Duncan, Division Director, State Veteran Cemeteries.
And Juan Renault, Deputy Commissioner, KDVA.
Mr. Chairman, we just want to thank you all for having us and allowing the time before this committee. House Bill 86, basically what it is, if you served in the National Guard and you wasn't deployed and being shot at by the Taliban, in other words, if you are still here, you're not allowed to be buried in one of our state cemeteries. And we believe that anybody that has served in the National Guard, took the same oath that we have with anybody else, that they are still considered a veteran. They have that full right to be able to be buried in one of our state cemeteries. That is the summary of that. And so Michael was denied of that because he was never allowed to go overseas. That is not his choice. He took the oath that he was willing, and his family knew the sacrifice that they was going to have to make if he was accepted and deployed. And so I'll turn this over to Alan Hears.
Good morning, ladies and gentlemen. Like I said, my name is Al Duncan. I'm the Division Director for our State Veteran Cemeteries. And just give you a brief two-paragraph on this bill. With the passage of the Burial Guard and Reserve Act of 2022 at the federal level, this allows Kentucky and the state veteran cemeteries to provide burial benefits to a specific group of National Guard and Reserve component veterans, their eligible spouses, and their eligible children that was not previously granted. We're talking about those National Guard or Reservist soldiers that were never called to active duty under Title 10 executive orders. They served their 1 week in a month, their 2 weeks a year, with no active duty time. They could have served 6, 8, 10 years in the National Guard or the Reserves. Then they chose the ETS from the military. These are that group of veterans that we're talking about being allowed to be buried in our state veteran cemetery. These are the guys that served during our floods. These are the guys that served during our tornadoes. Those are the individuals we're talking about.
And I would also like to add, Mr. Chairman, that all the cost is in House Bill 6, so that is all covered.
All right. I think Senator Boswell likes to hear that. We do have some questions, but I do have a committee sub 2. No? All right. Senator Smith.
I do. Thank you, Mr. Chairman. I'll keep my comments brief. In the fall of 1942, a bomber division en route for just ordinary training, something they were doing quite often. That route that they flew was down across eastern Kentucky, across Buckhorn Lake at that time, that had just been converted over from what was known as Bowling Town, as that area was flooded. And they crashed, and everybody on board had lost their life to it, but because the effort, there were so many of our men and women serving abroad that there wasn't anybody to try to go help and retrieve those bodies. And so we had our local Boy Scout group, Troop 90, which I was fortunate to be the district commissioner of and troop leader for many years, went over there and went through there. The wreckage is still there. So we understand this personally. Just because those men and women did not die in the theater of Europe or Asia, that they were still as heroic as any other member that we did have. And I have flags in my home, a family that did perish in those theaters. But we should be just as proud of them as we are anybody else. They had signed up, as it was said earlier, and would have gone wherever they were sent. But their lives were just as valuable as any other ones lost. So I do applaud this piece of legislation, and just wanted to give us this brief tip of history that Kentucky plays a big role in, because we wore a big bomber run in those areas, and through just faulty equipment and different mistakes, a lot of these young men and women serve their country. They pay the greatest price that you have to give, and their families suffer just as greatly. So there is absolutely no shame on that, and any part of this legislation that helps clears that up, I support full-fledged. So thank you, Mr. Chairman.
Thank you. Got a motion, but get a second real quick. Got a second. Senator Higdon has a comment.
Thank you, Mr. Chairman. And the minimum requirements, we talked about reserve and National Guard being eligible. What are the minimum requirements that a veteran that served in the National Guard and the Reserve that didn't have any active duty time and were never deployed or shot at?
Sir, the minimum requirements is they have to have completed their first term of enlistment. So, for example, when they enlist into the National Guard, they must, if they serve for 3 years, they must have completed that first 3 years of enlistment, and then they would be eligible with a honorable or under the conditions of honorable. Then they would be eligible for this. And this is the same exact terminology that we use for a regular veteran in the national cemeteries and or our other state veteran cemeteries.
Okay. Thank you, and thank you, Mr. Chairman.
Thank you. Any other? All right. Mr. Secretary, please call the roll.
Senator Berg. Senator Boswell. Senator Deneen. Senator Harper Angel. Senator Higdon. Senator Meredith. Senator Smith.
Aye.
Senator Westerfield. Senator Williams. Senator Wilson. Chair Girdler.
Aye. House Bill 86 with amended as passes with favorable expression. And that same should pass. So thank you, Mr. Weston.
Thank you, Mr. Chairman, Committee. You'll have a good day. Thank you.
Thank you. Thank you all. All right. I think the reason the crowd's here today is we've got Senate Bill 147 and we got Senator Tishner. And anybody you have that wants to come forward with you, going solo. Oh, man. We do have a Senate sub.
Yes, we do have a committee sub.
Got a motion on the sub. Got a second on the sub. All in favor of the sub signifying by saying aye. Aye. All opposed say nay. All right. We're going to have a discussion, and we're going to give you about 10 minutes. We got to be judicial meets somewhere. Where you meet at, Senator Westerfield? All right, at 10 o'clock. So he's going to run off at 10 o'clock. So some of us going to have to run with him.
I will be brief.
The committee sub is adopted, and now we're going to do discussion briefly if you can, and then we'll get into and committee members. I would ask when we get to questions, do the questions, and then your dismay or approval of the bill will be explained with your yes or nay vote. Thank you. You may proceed.
Thank you, Chairman Girdler. I want to really briefly go over the committee sub changes and apologize to the crowd that's here because the process doesn't allow for them to see the changes before it's brought before committee. So I want to make sure I clarify what those changes are so that they're aware. In Section 1, we've removed the term mentally competent adult. We have added a reference to current definition in statute of obscene matter as defined in KRS 531.010. In Section 2, we've changed the definition of adult-oriented business to say regularly hosts a performance with sexually explicit conduct. We've changed the definition of drag performance to say drag performance with explicitly sexual content and moved that definition under the definition of adult cabaret. And we've also removed universities and colleges from the definition of educational occupancy. SB 147 is a bill that will set into place a statewide regulation of adult-oriented businesses. Statewide regulations of adult-oriented businesses are not uncommon in the United States. In fact, much of this language was modeled after different legislation in other states that currently exist, specifically Tennessee's, which has been in place since the 90s. Missouri, Arkansas, Texas, Alabama, Ohio, Georgia, Kansas, Louisiana, and Florida all have similar statutory regulations in place. SB 147 will continue to allow local governments to enforce pre-existing ordinances and retain the authority to adopt future ordinances concerning licensing, zoning, and operations within the local government's jurisdiction that are at least as restrictive as these measures. The bill defines adult-oriented businesses to mean an adult arcade, adult bookstore or video store, adult cabaret, adult theater, or any establishment that regularly hosts any performance involving sexual conduct that is defined in the bill. The bill determines an adult-oriented business shall not be within 933 feet, which is the average city block, of a child care facility, children's amusement establishment, park or recreational area, place of worship, or a building with educational occupancy, which is the use of a building or structure by persons assembled for the purpose of learning, whether private or public, and includes academies, care centers, kindergartens, libraries, preschools, schools, and seminaries. An adult-oriented business shall ensure that no minor gains access and no obscene, harmful to minors, or patently vulgar matter or performance is visible to minors, and they shall not employ a person under the age of 18. The Commonwealth of Kentucky has long set regulations around different businesses in order to enact measures to protect its citizens. We regulate and monitor insurance, horse racing, the financial industry, alcohol, real estate. The list is long. The intent of this bill is to set a regulation around this industry to ensure we are protecting communities and minors within those communities from exposure that may lead to negative adverse secondary effects. Chairman Girdler, I'm open to questions.
All right, I've got some people signed up to speak.
Okay.
You may, what I want to do is those that's for the bill, I'll give you 10 minutes. If those that are for the bill would come forward, I'll give you 10 minutes. And then those against the bill will give you 10 minutes as well. And we do have Senator Westfield, you want a question now or you want to wait till after? You want that's fine.
Thank you. Chairman, I appreciate that. Two quick questions, Senator. I want to commend you. I've reviewed the sub. I don't like these businesses any more than you do, but it appears you've worked really hard to try to make this First Amendment compatible. And I appreciate that. I had two quick questions. One, on page 4 and 5 of the sub, you go through the educational occupancy, and the first thing I thought about a homeschool, but that's obviously, it's an individual's home, but I'm more concerned about homeschool associations. Would that, do you think, fall under your private association? You just referred to it as where people assemble for the purposes of education, whether private or public in nature, and I think that would include, like, in Christian County, there's a group of homeschool parents that get together for certain activities or certain subject matters. Do you think that would qualify?
I think that it will. I think it may also be protected under the child care facility definition, which is a private home that is the primary residence of an individual who provides full or part-time care at that residence for 6 or fewer children. So it could possibly fall under that definition as well.
Thank you. I think the second question I have, the only other question I have so far, Mr. Chairman, Senator, you mentioned, and this is one of the changes you made in the sub, page 3, line 8, regularly features. Is there any guidance for what that could mean? I know what I think that means.
Right.
But I don't know what
Well,
you think that means.
Yeah, I know. It was a hard one to define, and if you put some standard around it that's too tight, it boxes in a lot of what the intent of the bill is
Sure.
to do. When I was speaking with our attorneys and bill writers, regularly is used in statute often.
It is.
And can be interpreted at the discretion of whoever is
Based on the
bringing-
facts you got.
Yeah, exactly.
Thank you. Nothing further, Mr. Chairman.
Thank you.
Thank you. You two gentlemen, introduce yourself, and you got 10 minutes.
Go ahead.
Thank you, Mr. Chairman. Thank you, committee members. How about that? Thank you, Mr. Chairman. Thank you, committee members. My name is Richard Nelson. I'm the founder and executive director of the Commonwealth Policy Center, and I'm here to testify on behalf of Senate Bill 147. I'm going to keep my comments brief, and for the sake of not being redundant, I'm going to get to the heart of what I wanted to share. Senator Titchener has articulated well the need for this bill and why it's being presented. The bottom line with this is that this proposal seeks to promote the health, safety, and general welfare of the citizens of the Commonwealth of Kentucky. It would bring statewide restrictions, as was mentioned, on sexually oriented businesses. Currently, there are none. Several other states have restrictions in place that have been upheld by the courts, similar restrictions. I'll bring the personal part of this, and this is very brief. 2 years ago, I was asked to speak to a group of women in Bowling Green who learned about a sexually oriented performance that was in a public area, and they asked me to speak to them to see what they could do to prevent this kind of activity from being promoted and to their grandchildren and from children in the community being exposed to it. I do have a couple of photos for you to look at that were actually taken at that event. And when it comes to the term sexually explicit, I think these would fall into that category, but I'll let you see for yourself if you care to look at them. Since then, nothing has been done at the statewide level to protect these children in all of Kentucky communities from this kind of activity, and that's a big reason why we're here and why this bill is needed. As was mentioned, Senate Bill 147 proposes to keep sexually oriented businesses 933 feet away from child care facilities, children's amusement establishments, including parks, recreation areas, public schools, libraries, and places of worship. I believe this is a practical bill that protects our communities and our children, and I ask that you pass this bill out of committee. Thank you.
Good morning. David Walls, Executive Director of the Family Foundation, Chairman Girdler, committee members, appreciate the opportunity to be here and testify in support of Senate Bill 147. I'll try to be brief as well. SB 147, we believe, is a common sense, straightforward, and necessary bill that will protect the citizens of this Commonwealth from the numerous adverse effects of adult-oriented businesses by setting up a baseline of protections and an important statewide framework of regulations that has been mentioned has been successful in many other states. It would simply provide reasonable protections for children from exposure and harm from adult businesses and performances by setting minimum distances, as been discussed, from places where children are present, including churches and education and child centers and parks. You know, I believe actually most Kentuckians might actually be surprised that some of these protections are not already in place. Importantly, this bill would also prevent sexually explicit conduct and performances on public property. Over the past several years here in Kentucky and across the nation, we've seen a growing problem and concern about adult-oriented performances, specifically marketing and targeting towards children, including in our public libraries, parks, and even in schools. Let's state the obvious: sexually explicit adult performances should not take place on public property and shouldn't be anywhere close to children. And I'm thankful that SB 147 would provide the needed safeguards to protect our children and our communities. Fundamentally, we believe government has a moral obligation and duty to protect Kentuckians from the adverse effects of these sexually explicit businesses that are mentioned in the bill. Can include sexual exploitation, human trafficking, public indecency and obscenity, and harm to children.
Again, I thank Senator Tishner for her tireless work on this issue, for bringing this important bill forward again. And on behalf of the Family Foundation's tens of thousands of supporters, partner churches, and advocates across Kentucky, we encourage you to take action on Senate Bill 147 to move it forward and protect Kentucky's children and communities. Thank you.
All right, thank y'all. We have Senator Byrd, got a question?
Yes, sir. Thank you guys so much for your presentation. My question goes to page 3. If you look at line 1 on page 3 of the sub, requires sexual conduct or nudity. Line 4, sexual conduct or nudity. Line 9, nudity. Line 10, nudity or sexual conduct. Under drag, the requirements are different. It has to be a performer who lip syncs, dances, sings, or performs before an audience while exhibiting an exaggerated gender expression. It doesn't specifically, it says explicitly sexual conduct. Can somebody explain, is there a different requirement for drag than for any other adult businesses in the state? And the type of drag shows that I'm used to, that do not have nudity, do not have explicit sexual performances, where do those fall under this? And why are we not giving the same, why aren't we using the same language in line 14 that we are everywhere else?
I appreciate your question, and I will tell you I have thought long and hard about this issue. And one of the things that in this process, I was invited to sit down with a drag performer from Louisville. And it was a great conversation. We had a great conversation. This was a point that he brought up. And this is a part of the legislative process, that we put a bill out, then we hear from our constituents and we hear from people who have concerns, and then we make adjustments. So the adjustments that I made to this previously in the original bill, drag performance did not have explicitly sexual conduct listed. And if you look at that definition of sexual conduct, it's very clear what type of performance we want to keep out of minors, in front of minors. It's not necessarily always about what someone is wearing. A lot of times it's the behavior of what they're doing. And that definition, if you flip to page, I believe it's page 6, you will see what sexual conduct means. And that is from current statute in KRS 510. The other thing that I would mention in considering this, as Mr. Walls mentioned, we're seeing some of these performances now come into the public sector, and I think it's important that we have two separate distinctions of drag performance. One that is sexually explicit, which I defined, and the one that's not, I didn't have to define because it doesn't pertain to this legislation. I hope that I'm explaining that well.
Actually, two. So if we're just delineating nudity and sexually explicit, why don't we just put adult cabaret? Why do we have to include drag?
Okay, I will say, because now we have two forms of drag. That one is in the public sector where they're going to drag queen story hour.
Okay.
They're not performing sexually there.
But you don't want that.
That's not what this bill does. It doesn't limit that. It would limit a sexual performance from going into the library. So we have two distinctions of drag now. We don't have any other distinction in the adult-oriented businesses that no other type of performance is trying to go into a public sector in front of children. We have drag is. So I want to make sure we define that sexually explicit performances stay in this context. And these are the ones that we're trying to keep minors away from.
I think I might understand what your goal is. I will say that, we have sexually explicit theater that it's not X-rated, where we have, people in various stages of undress for a purpose other than to be sexually enticing to a minor. And it is not necessarily inappropriate for a minor to be in that situation. Sometimes it's actually very appropriate. So I'm confused. Why don't we just say that overt nudity and sexually explicit performances are not done in public? Why are we feeling the need to include drag separate from adult cabaret, other than the perception that the community gets, which is that you're trying to specifically control one art form?
Thank you. Senator Berg, you can leave those to the, on when you vote, and the questions. It was.
Do you mind if I answer?
Yes.
Okay, thank you. I think I'll just reiterate, we in some ways, this bill is putting a measure of protection around performances that aren't sexually explicit, if that makes sense. Because we have two different, that's not, performances that are sexually explicit from the drag community are what's specifically mentioned in this that we want to keep minors from. It's not broad, it's very specific as to what type of drag performance is sexually explicit and which one should be kept away from the public, and I hope I'm explaining myself well.
Let's do this. I've got some people that are opposed I'm gonna give 10 minutes to, and then if there's something that probably could change in the bill, you could file an amendment to that. All right. Thank you all. Don't go far, Ms. Tishner.
Okay.
Those that oppose, I'm going to give you 10 minutes. You can split it up, or you can elect one person to do it all. And I want to recognize the lady that, or the person that confused me last time. Polly, I'm so glad to see you. You've made my year last year, so I'm glad to see you again. Thank you. Those opposed, and I think come forward. You want to elect a spokesman, or you want to take, if there's 5 of you, take 2 minutes each, or whatever.
I think the latter would be great, Mr. Chairman, because I think I want to speak upon constitutional issues, and the other speakers here will speak upon the experience issues, correct?
Well, what we're going to do, we're going to have you to introduce yourself for the record.
Fantastic.
And then you can, if you want to go first, sir, you're more than welcome. Oh, well, you're going to go first. All right, whatever. All right, introduce yourself, and I'll tell you what, I'm going to let Polly go first because I've missed her. Go ahead.
Good morning. As some of you may remember, my name is Polly Tix. I was here last legislative session, and I'm excited to be back. I would like to start by recognizing that the intent of this bill is to promote the health, safety, and general well-being of everyone in the Commonwealth, with an emphasis on children. I'm sure that every person in this room would agree that we have a specific need to address the health, safety, and well-being of children. With that being said, targeting drag performances is by far one of the least impactful pieces of legislation that could be proposed to meet those needs. I would argue that resources, time, and money would be better spent ensuring every child in Kentucky has access to affordable health care, well-funded education, and clean water and nutritional food. Addressing those needs would be more impactful on the lives of children and every Kentuckian in our Commonwealth. As we have seen many times before, this bill has numerous gray areas and allows for multiple interpretations of the law. Although you define sexually explicit content and in a last-minute sub provided inadequate definitions of sexually explicit drag performances, it is still unclear if individuals who have any disapproval of drag could bring civil cause of action against those performers. I have a great deal of uncertainty that these restraints would be applied equally. You mentioned it is not always the clothing, but how it is worn and the behaviors behind it. I am unsure if these restrictions would be applicable to places such as Hooters Bar and Grill that could arguably be seen as sexually implicit, and although their outfits may meet the definitions of being okay, their behaviors may be interpreted as provoking sexual enticement. Ultimately, it is the responsibility of our elected officials to draft and implement legislation that has more answers than questions. This bill not only leaves Kentuckians with more questions than answers, but it also allows for a greater risk of certain Kentuckians to be targeted for harm and discrimination. I urge you all to not move this bill forward, but if you must move it forward, to take the due diligence to make the amendments and to really meet the kind of nuances that this bill would address. Thank you.
Thank you. Who's next?
Good morning. I'm Andrew Schaffline from Jefferson County. I'm also a drag performer named May O'Nays. I'm the aforementioned drag performer that the senator met with a couple weeks ago. Polly hit the political stuff real good, so I'm going to speak to a different component. I'm not also just a drag queen. I am a parent. I have 3-year-old twins. And this bill has been written allegedly to protect children. Of all the threats to children, of which there are many, drag, I don't believe, is one of them. As a parent, it's our job to decide what art and what culture is appropriate for our children to see. For instance, I don't know that I would take my kids to a WWE wrestling match. It's quite violent, or a gun show, or maybe a Hooters. But these are all places that children are allowed to go. And isn't it great we live in a country where we can have these vast experiences and all make different decisions for our families? But what I really want to ask is, I think when the senator and I sat down, we saw each other more clearly. Some edits were made to the bill, not all of the ones I'd like to see. So it's my request to all of you here, before we start voting on ways that, on subjects that are going to impact our livelihoods up here, please sit down with a drag queen to just talk about drag. I will come to Frankfurt anytime. I don't want to speak for Polly. Polly seems like she would too. I would just really, really ask, sit down with one of us at least once before we start legislating about us. I appreciate y'all. Thank you very much.
Next.
My name is Anthony Munger. I am a social worker in Louisville, and I have also been in the bar and restaurant industry as a bartender and a manager for 25 years. And I'd like to echo Senator Berg's sentiment that this bill is unnecessary because as far as my liquor laws go, this is already on the books, and that is very, very explicit about what can and cannot be shown. As a matter of fact, that liquor license, which is common across the country, is how I learned the word perineum. It's already being enforced. And the only time I've ever had to enforce it myself in the bar is with a bachelorette party, because it also refers to simulated perineums, shall we say. The effect of this bill is broad and vague. And of course, I wrote this before the amendment. So thank you, Senator Titchener, for making those clarifications on the definitions. We do appreciate that. My concern is that the bill is broad and vague, and it has restrictions that could be seen as threatening to family-friendly activities typically featured at Pride festivals. These festivals are not only cultural celebrations, but also significant economic drivers for local communities, attracting tourists and supporting various local businesses, including those owned by LGBTQ individuals. The loss of revenue for area businesses due to canceled or scaled down Pride festivals could be substantial. Restaurants, hotels, shops, and other service providers benefit from the influx of visitors attending these events. Additionally, LGBTQ entrepreneurs who rely on Pride festivals as platforms to showcase their services or artistic expressions could face financial setbacks and decreased visibility within the community. This bill raises significant concerns regarding its fairness, its legal implications, and its effectiveness. Its ambiguous definitions are directly targeting LGBTQ individuals and their expressions when similar laws are already being enforced. This not only marginalizes and stigmatizes these individuals, but also infringes upon their rights and free expression of assembly protected under the First Amendment. I don't want sexually explicit shows in front of kids, but here we are, professionals who know what this language is and how to debate it, and here we are turning it over to individuals and opening it up for civil lawsuits, opening it up for tying up the courts, and however police officers in different communities try to enforce this and try to interpret this law. And I think that that is dangerous. This law does nothing. It just hurts us. Thank you.
Next.
Good morning, Chairman and members of the committee. Thank you for allowing me to testify today. My name is Tamara Weeder. I'm the State Director with Planned Parenthood Alliance Advocates, and I'm here in strong opposition to 147. Make no mistake, this ban on drag performances is designed to target queer Kentuckians. This is just another attempt to force them back into the closet by targeting those who are allowed to wear certain clothing, look a certain way, and be in certain spaces. This will have devastating impacts on trans and non-binary folks as the bill seeks to criminalize their very existence by labeling gender expression and gender-affirming clothing as drag, but maybe that's the point. At Planned Parenthood, we proudly partner with drag artists and gender nonconforming folks for adult community outreach programs. These programs are age appropriate and bring fun and accessibility to our sexual and reproductive health education programming. Our partnership with drag artists would be severely restricted, if not outright banned, under the broad and expansive definitions of this bill. Political extremists want to take us back to a time when every trans person was forced into the shadows. They want every LGBTQ person to be afraid to be who they are. They want to legislate them out of existence by limiting how they dress, style their hair, and present themselves in society. They want to stop them from living authentically as themselves because the freedom to do so threatens the status quo. Discrimination based on how people look, the clothing they wear, where they frequent, and the art they perform is not only wrong, it is unconstitutional. We are protected from government limits on our freedom of expression, including how we express our gender. Kentucky families have a First Amendment right to attend these events, and performers and business owners have a right to offer them. No matter our genders, what we look like, how we love, or where we come from, we all should be treated with dignity and respect. And we need to protect LGBTQ people and their vision in society. And I want to mention, my husband is a 26-year active duty service member. He has served this community. This is not what he went to war for. Thank you.
Sir, constitutional?
Yes, folks, good morning. My name is Michael Frazier. I am the lobbyist for Ban Conversion Therapy Kentucky. I am also Kentucky's First Amendment award recipient for protecting First Amendment rights equitably and indiscriminately here in Kentucky. I'm also the former legal research clerk for Karen K. Caldwell, Ernesto Scorsoni, and Tommy Wingate, and also study underneath the former Solicitor General for the Commonwealth of Virginia. And I'm here to talk about this bill, particularly when it comes to its constitutional limits. I appreciate the good intentions of Senator Tishner and, frankly, my colleagues, Richard Nelson and also David Wallace, both working together to make this bill more narrowly tailored to ensure that we get into First Amendment constitutional compliance. But there are still a few issues within the bill. First and foremost, we do have a facial issue when it comes to the word prurient. And while the bill does use the word prurient, and the issue that comes into this is Spokane adult arcades versus Spokane, Washington, 1985, which the Supreme Court has defined that prurient left undefined from difference of prurient interest, in which we see within the Miller test from 1973, and then also when it comes to Ginsburg versus New York, 1993 case as well. Those two tests, those are not the same thing as keeping the word prurient left alone. So there is a question of constitutional vagueness when it comes to this bill. So when we also look into not only just a facial vagueness issue within the bill, we also have an issue of an applied challenge. Because what we're telling cities, particularly parks, public places, and while the definition of sexual exploitation and also sexual interest helps the bill, leaving it further implications in the bill for cities to find content, specific content related to drag queens, and having cities to deny these performances and also review these performances to see if they comply with the sexual definition within the bill does create an undue burden upon the free speech rights of the drag queen performers or within the content message, and that is a specific content message. So the bill gets into applied issues of non-neutral content discrimination within the bill. So there are two alarming factors when it comes to looking at the First Amendment interests of this bill. And while we do appreciate the bill getting more narrowly defined, we do appreciate it becoming better.
Yeah, all right.
Sure.
I was going to have you wrap it up.
Yeah.
We do have one question from Senator Meredith.
A couple of comments and a question, Mr. Chair, if I might.
All right, go ahead.
First, the argument about lost revenue, to me, it's a hollow argument because to suggest anything that generates a return on investment is fair game. I'm sorry, that's not a standard that I think is acceptable. Secondly, to suggest that this group of legislators is pursuing this to target queer Kentuckians, I will vehemently disagree with that. The intent of each and every person here, and I know each and every one of them, is to protect children from matters which they cannot possibly understand. I'm a grandfather with 7 kids. I think one of the things that has driven this is drag queens at libraries. And I don't know how my 4-year-old granddaughter could possibly understand what is occurring in that kind of environment. It leads to mass confusion. And I guess I'd like to know, what do you think is possibly could be considered educational or entertainment value to a 4-year-old in that kind of environment? What are we trying to accomplish?
I'd like to respond to that by pointing out in previous questioning of Senator Tishner, she mentioned that performances at libraries was not included. So the question I'm a little confused about in that response is, if the things that kind of motivated this was drag queens reading to children, that concern isn't being addressed in this bill. The other thing that I would like to point out in terms of the question of what educational or entertainment value would be offered to children is just the freedom of expression and the reminder that regardless of who they love, how they dress, or how they want to present in the world, they are protected, they are loved, and they are seen. By making this kind of streamline conversation of how kids are supposed to act or how they're supposed to dress without this kind of opportunity to explore different things in safe and regulated ways, we're kind of stunting what children are allowed to explore and develop. And in doing these drag queen story hours, the books that are read represent different types of families, and the queens or kings or performers themselves represent different types of Americans that belong and are allowed to exist in this country.
Motion on the bill.
Got a set motion and a second. Mr. Secretary, please call the roll, and you can explain your yay or nay vote, and give you 2 minutes. We got to get Westerfield, Senator Westerfield, to judicial, so he can learn about constitutional law. Or all right, they won't start without him. Thank you.
Senator Berg.
Explain my no vote. Honestly, this is a better bill than what we've been presented in the past. It still, in my opinion, is not good enough. 2 minutes is going to go quickly. First of all, I have not received a single email from a single constituent in favor of this bill. The only email I received in favor of this bill came from the Family Foundation itself. Second of all, I want to make sure that the people of this state have full understanding of what the goals and where the money is coming from and who the people are that is bringing this legislation to our state. Because if you are aware of what the Family Foundation and what the Alliance Defending Freedom and what these Christian national groups are trying to bring into this state, you will register and you will vote. 70% of Americans do not want this. You know, a couple of weeks ago, Greece, the first Christian Orthodox country, passed same-sex marriage. And their prime minister said something that I think bears repeating. People who have been invisible will finally be made visible around us. And with them, and this is what I want my colleagues to begin to understand, because the world is changing. And with them, many children will finally find their rightful place. The reform makes the lives of our fellow citizens better without taking away anything from the lives of the many.
Senator Byrd. You must be.
Thank
like
you.
All right, thank you. Mr. Secretary.
Senator Boswell.
I'd like to explain my vote.
Go ahead.
Well, first of all, thank you, Senator Tischler, for bringing this bill. You are a champion of children's rights, and I want to thank you again. There's been talk about amending this bill, and I want to say this. If there's going to be amendments to this bill, I personally would favor a stronger amendment. Now, I think it's very interesting that the question was asked by Senator Meredith, even though it's not in this bill. What is the value of taking drag queen shows into our grade schools and our public libraries? And I didn't hear an answer to that. So, anyway, that's it.
Thank you.
Senator Deneen. Senator Harper Angel.
Explain my no vote, Mr. Chairman.
Go ahead.
Mr. Chairman, I don't really care how people look or what they want to wear or where they want to perform or what they want to read. But like Polly said, I do care about properly funding our education system, making sure our families have groceries and have access to affordable health care. And I know that this legislation has taken many, many hours, and I just wish that we would spend our time actually facing the real issues that are facing Kentucky in a more solid way. I vote no.
Thank you.
Senator Higdon. Senator Meredith.
I'll explain my aye vote, please.
Go ahead.
First, I want to thank Michael Frazier for testifying. Sharp young man. I've relied on numerous occasions to help me see the correct course of action. I think there are some constitutional challenges to this, and Senator Tischner, I'd encourage you to talk with Michael and to see if that could possibly be addressed, but I always appreciate you being here. Also agree with Harper Angel, Senator Harper Angel. I don't care how people dress. I don't care how they act. I don't care what you do in the privacy you do in your home, but I am here to protect children. And I still contend that we're exposing things to children that they cannot possibly understand or comprehend. And that creates a trauma in their lives as well. And we need to be sensitive to that. Let children be children. So I vote aye.
Thank you.
Senator Smith.
Explain my aye vote if I could.
Go ahead.
I appreciate the work that's been done by the sponsor. I appreciate the testimony that's been placed here today, and I think it's good food for thought. I personally am a big supporter of the arts, both in participation and financially. In the eastern part of the state, we met with the orchestra last night about bringing more of those opportunities to children of the mountains to be able to see the beautiful cellos and violins and something they may not have access to. So I think culture is an opportunity for areas of the state that they're sorely lacking. It just begs to reason, as somebody who's followed the arts, as I do, and many others do, for the audiences for this much talent stuff, why are we directed at children? I mean, most of the stuff that I've got, I mean, for all of us who've been parents, you buy these wonderful gifts, and the kids play with the cardboard box, and we know that they're kids. I mean, you can try to do that, but they're still at that stage of the game where they're trying to figure small things out and putting these complex things on the reader sometimes at the farthest extent of where we are as adults to understand the full artistic value of what a performer's put into it. So I think maybe we're missing each other here. So I encourage the arts. I think that there's a place for it and people that enjoy it, and it's inspiring and leaves you thinking like a piece of work or a good glass of wine. But I am worried about the audience that we're targeting right now, and just because of that, I vote yes. But I do hope this continues and that there's an opportunity to have something good come out of this. So thank you.
Thank you.
Senator Westerfield. Aye. Senator Williams.
I'd like to explain my aye vote. So I think this just puts drag performances on the same par that every other performance is. I mean, we have G, PG-13, G-17, R when we're looking at video. We have performances in theaters that are sexually explicit. This is about protecting children from sexually explicit content. Yes, it is taking and segmenting drag performances, but actually in statute, a male as a drag performer can perform acts right now that a female could not. Okay, so you're just putting everybody on the same playing field as regard to sexual explicit performances and rating those performances. So that's why I vote aye.
Thank you.
Senator Wilson,
Sticky area.
Chair Girdler.
Aye. Senate Bill 147 as amended passes favorable expression. That the same should pass. So thank you all. Appreciate your attentiveness and your kindness. Thank you. I'd like to address a motion to adjourn. Let's do it.
I'm the official second.